In the span of a few years, the United States has faced multiple assassination attempts against a president, the targeted shooting of a healthcare executive, and the public murder of figures like Charlie Kirk. This violence has targeted federal law enforcement directly. Agents and facilities tied to immigration and customs enforcement have seen violent assaults increase by 8,000%, including an attack from a sniper nest in Dallas. Fighting a centralized foreign army is a matter of clear borders and uniforms. Confronting a decentralized, domestic political movement creates a jurisdictional maze where local crime and political speech become inseparable. Before the federal government can deploy its intelligence and law enforcement apparatus to dismantle a threat, it must first solve the bureaucratic problem of defining exactly who the enemy is. That solution arrived in the form of National Security Presidential Memorandum 7. This historic directive officially recognizes left-wing violence as a form of political terrorism. The memo directs every intelligence and law enforcement agency in the country to work under a single mandate. Their goal is to identify, defund, and prosecute these domestic networks as unified criminal conspiracies. To classify the threat, the text of NSPM-7 uses specific ideological markers. It identifies anti-capitalism and hostility toward traditional morality as the baseline characteristics of these domestic networks. A memorandum provides the legal scaffolding for state action. However, to mobilize the public, the administration must translate these dry legal definitions into a broader narrative. Stephen Miller took the policy framework of NSPM-7 and translated it into a visceral, public-facing threat taxonomy. In this system, dissenters are stripped of sincere ideological conviction, replaced with a psychological diagnosis of deep-seated envy and hatred. The target of that envy is the traditional, ordered family. Seeing happiness in others triggers an inadequacy that becomes a desire to inflict pain. This move shifts the government's focus away from criminal actions to prioritize the internal, subjective thoughts and emotional states of its citizens. The classification system moves past psychological markers to include literal, physical traits. Miller claims that these dissenters are visibly deformed in their appearance and dress, arguing that not a single person assembled in these demonstrations looks like a normal human being. He frames this as a biological reality. The physical appearance of the protester is presented as a manifestation of their inner political hatred, written directly onto their bodies. This ideological and physical taxonomy is captured in a single metaphor. Miller defines the movement as a fatal cancer to civilization. The administration has officially reclassified a political movement as a biological disease infecting the nation. The state has rewritten its internal security logic around these new classifications. Domestic terrorism is no longer measured by what a person does. The new standard is who a person is, defined by their intrinsic identity and appearance. This type of classification carries specific historical implications. When a state defines a segment of its population as a deformed, envious cancer, it eliminates the possibility of negotiation or rehabilitation. A cancer is not debated, it is excised. NSPM-7 and the administration's rhetoric have provided the legal authority and the linguistic permission for total domestic conflict. But classification is only the first step. To fight the enemy it has just defined, the state must now build the physical machinery to enforce it.
The state does not need a grand courtroom drama to dismantle a political movement. Long before a judge strikes a gavel, the target is quietly starved. The process begins by severing the organization's operational arteries. Once an entity is classified as a security threat, a sophisticated administrative machine kicks into gear. Its immediate goal is not to secure a criminal conviction. It is to strip the group of capital, legitimacy, and the basic capacity to function. This interlocking triad operates as a closed loop. Treasury initiates financial debanking. The IRS executes aggressive regulatory action. The DOJ expands material support doctrines. We'll trace this machinery step by step, from the banking sector through the First Amendment's constitutional limits. The primary objective of this system is to bypass the heavy burden of proof required in the criminal justice system. By aligning these three agencies, a state can functionally destroy an organization through pure administrative fiat. The squeeze begins at the Treasury Department.
Under National Security Presidential Memorandum 7, it is mandated to investigate and disrupt targeted domestic financial networks. Section 2I of the memorandum specifically directs financial institutions to trace illicit funding streams and deploy their own investigative tools against these networks. To execute this, the government relies on Suspicious Activity Reports, or SARs. Federal agencies guide banks on specific behaviors and patterns to flag, effectively directing them to file SARs against the targeted domestic groups. Banks operate in a state of extreme risk aversion. When federal guidance suggests a client might be tied to a domestic threat, financial institutions will automatically sever ties rather than risk federal noncompliance. A single SAR can trigger a cascade of automated account closures across the banking sector. On the ground, the impact is immediate. The organization loses the ability to process payroll, accept donations, or pay basic infrastructure costs. The mere issuance of federal guidance creates an automated, preemptive financial collapse for the target. Not a single criminal charge has been filed, yet the organization is effectively bankrupt. Simultaneously, the second cylinder of the engine fires. The Internal Revenue Service moves to revoke the organization's institutional legitimacy. The IRS can initiate a standard 501c3 tax-exempt examination. This process is designed as a grueling, document-heavy administrative burden that forces the group to justify its exempt purpose. The agency issues continuous information document requests. These requests are weaponized to bleed an organization of its remaining time, focus, and legal resources, paralyzing whatever operations survived the Treasury's debanking. But the standard audit process includes a right to appeal. For designated terror networks, the executive branch bypasses this entirely and deploys a nuclear option. Under Internal Revenue Code Section 501p, the IRS can instantly strip an organization's tax-exempt status. There is no standard appeals process. The designation is immediate, and the status is suspended indefinitely. A 501p designation ensures any remaining philanthropic funding dries up overnight. In one strike, the state eliminates both the target's regulatory legitimacy and its remaining financial lifeblood. With operations and finances frozen, the final stage of the trap snaps shut. The Department of Justice applies the Material Support Statute, 18 U.S.C. Section 2339b, to criminalize the individuals inside the network. The legal framework for this trap was forged in the 2010 Supreme Court case, Holder v. Humanitarian Law Project. The plaintiffs in that case wanted to teach international law and conflict resolution to designated groups. They argued this was protected speech and peace-building, not terrorism. The Supreme Court disagreed. They ruled that even under strict scrutiny, otherwise protected political speech becomes criminal conduct if it is done in coordination with a designated group. The rationale was that providing any service, even peaceful training, frees up resources within the organization that can be used for violence. Holder effectively erased the strict legal boundary between independent advocacy and criminal support. From there, lower courts aggressively lowered the threshold for what constitutes coordination, most notably in the First Circuit case, United States v. Mahana. Mahana allowed the state to classify decentralized internet activity as material support. Translating documents and posting online advocacy were deemed prosecutable offenses, even without direct physical contact with the targeted organization. This legal evolution eliminated the requirement for direct physical coordination. The legal trap around domestic political dissent was now tightly closed. When these three systems are activated together, the financial, regulatory, and legal pressures converge to crush a targeted entity. This administrative closed loop is meticulously designed to ensure organizations collapse under sheer bureaucratic weight. The target is neutralized long before a trial date is ever set. But there is an absolute limit to administrative power. To physically imprison individuals under material support statutes, the state cannot rely on fiat alone. Eventually, the government must step outside the realm of unilateral executive orders and enter the adversarial arena of the judicial system, which leaves us with a final question. What happens to this flawlessly engineered machinery of state power when it is finally forced to justify its logic to an impaneled jury of ordinary citizens?
In early 2026, the streets of Minneapolis became a volatile testing ground for a new, highly aggressive form of civic resistance. A network calling itself Direct Action Minnesota deployed a targeted strategy known as commuting. Activists would identify federal immigration and law enforcement officers, log their license plate numbers in shared databases, and follow them from government buildings to their private residences. To paralyze federal vehicle movements entirely, they set up hard blockades, using flipped trailers and heavy metal check hedgehogs to lock down the roads surrounding federal facilities. These localized militant tactics forced an immediate crisis. The state faced a resistance that was becoming more effective at obstructing federal operations, setting up a massive legal collision with the public. Historically, the aftermath of a protest is resolved here, the local municipal courtroom. In these local venues, the ultimate democratic check on state power sits in the jury box. 12 citizens drawn from the community must decide if an act warrants a criminal conviction. This introduces jury nullification. If a jury believes a prosecution is politically motivated or unjust, they have the unwritten power to refuse to convict the defendant, regardless of what the law says. The government faced a procedural trap. Street resistance was expanding, but local prosecution offered no guarantee of a conviction, threatening to make the state's authority look optional in its own courts. Rather than risk losing in local courts, the executive branch decided to change the legal battlefield. The administrative tool for this shift was National Security Presidential Memorandum 7. This directive redefined the state's response to organized political violence. It activated joint terrorism task forces to investigate standard political protests and instructed the Treasury to identify and disrupt the financial networks that fund them. The core mechanism was a categorical expansion. Actions previously handled as trespass or property damage were now swallowed up by the federal domestic terrorism umbrella. This was more than a change in terminology. It was a calculated transfer of legal jurisdiction, designed to strip away local oversight. On June 16, 2026, the Justice Department executed this strategy, indicting 15 members of Direct Action Minnesota. Instead of local nuisance laws, the activists faced a barrage of federal charges: conspiracy to impede a federal officer, interstate stalking, and solicitation to commit a crime of violence. Rerouting these cases into the federal pipeline surgically bypasses the power of a local jury charge, is psychologically and legally restricted from acquitting a defendant who has been formally charged with a massive federal terror conspiracy. The state successfully rewired the judicial machinery to ensure convictions, effectively crushing the resistance before a jury could ever weigh the political context of the protest. The impact of this legal maneuver hit the streets long before any of these cases actually reached a courtroom. This strategy relies on what researchers call psychological siege. By expanding the terrorism definition to include standard activist behavior, the state creates a persistent threat that lives in the mind of every organizer. The pressure shows up in quiet, defensive shifts. An organizer decides to stay home. A donor stops their recurring gift to avoid a paper trail. A nonprofit scrubs any mention of migration, race, or gender that now triggers federal scrutiny. Step by step, the state's victory moved beyond the courtroom. It successfully triggered a containment of the entire ecosystem of democratic dissent. The democratic check and balance system was deliberately circumvented. The community jury has been sidelined, and the act of protesting has been categorized as terrorism. When a legal architecture is designed to bypass juries and guarantee federal outcomes, the traditional guardrails have essentially been removed. Which leaves one final question: what happens to a society when the legal path for dissent is closed? Homeland Security Advisor Stephen Miller warned foreign diplomats, left-wing terrorism always ends in the mass imprisonment of political enemies and the stripping of their fundamental rights. Miller is describing the exact outcome of the policy directive he helped author. By claiming the state is under threat from an unrelenting enemy, he is setting the stage for the very crackdown he claims to fear. This strategy is codified in National Security Presidential Memorandum 7, or NSPM 7.
While it appears to be a standard law enforcement memo, its primary function is the reclassification of domestic political dissent. By labeling domestic protesters and political opposition groups as anti-fascist terrorists, the administration shifts them out of the civilian legal system. Constitutional protections like the right to a fair trial and protection against arbitrary search vanish once a citizen is moved into the category of a national security threat. This change requires no vote in Congress and no public debate. It is a redefinition of citizenship achieved through a single executive memo. To see where this leads, we must look at how other governments historically used this exact pattern to remove the legal guardrails of democracy. In February 1933, the Weimar Republic faced its own catalyst for emergency powers. Following the fire that gutted the Reichstag building, the government issued the Decree for the Protection of People and State. The Nazi leadership used the blaze to argue that their political opponents, the communists, were launching a violent insurrection that required immediate, ruthless intervention. The decree suspended the rights to personal liberty, freedom of the press, and the privacy of communications. It was framed as a temporary security measure to protect the public. This suspension of rights created a new legal instrument, Schutzhaft, or protective custody. Protective custody meant the police could detain any citizen indefinitely without a warrant, a lawyer, or any form of judicial review. In 1933, the state didn't need to defeat the law. It used the law to create a zone of permanent exception where constitutional rights simply cease to exist. The modern United States is not 1933 Germany. The two eras are separated by different cultures, different global contexts, and different political systems. American institutions possess centuries of legal precedent and a scale of inertia that the fractured Weimar Republic never had. But while the history is different, the logic of the two policies follows a shared trajectory. NSPM 7 takes isolated, unrelated incidents of local unrest, alleging a vast conspiracy against the United States. The directive then orders federal task forces to investigate organizations and funding sources of political opponents, bypassing standard limits on domestic law enforcement. In both cases, the language of national security is used to justify state surveillance and the preemptive silencing of dissent. This directive directly threatens the First Amendment. It treats standard political association as a form of terroristic recruitment. It also erodes the boundary between local policing and the federal national security apparatus, giving the executive branch direct reach into local communities. By pushing for aggressive interrogations of a person's ideological beliefs before they have even been charged with a crime, the memo effectively removes the presumption of innocence. When these tactics converge, they create a persistent framework for criminalizing systemic dissent. We are taught that the end of a democracy is a violent event, tanks in the streets or a military coup. But history suggests it happens more often through legal loopholes. Most democratic guardrails are dismantled quietly, from within the system, by leaders who claim they are only trying to restore order. The process is complete the moment the public is convinced that their political neighbors are actually enemies of the state. Legal protections and constitutions have no power of their own. They are only as strong as the people's willingness to defend them. Those words on paper cannot protect a public if the government is allowed to decide exactly who they apply to.